Hello, everyone. This is Haley Hansen. I'm a partner and the leader of Husch Blackwell's Higher Education Group. We're excited to be talking with you today about the final Title IX regulations and their effect on your campus. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use today. I'd like to take a minute and just highlight a few for you. First, we will try to answer some questions if we can during the program, but if you have questions, we really encourage you to submit them to your Husch Blackwell representative. As you know, we have 30 higher education lawyers, and we would be happy to take questions in that format. We do truly appreciate audience participation, so thank you for following with us and submitting those questions to your Husch Blackwell representative. Also, there's an icon for your viewing preferences today. So you can expand your slide area by clicking on the Maximize icon on the top right of the slide or by dragging the bottom right corner of the slide area. If you have any technical difficulties today, please click the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the Resource List icon that looks like a folder on the bottom of your screen. And we also placed in there a summary of the final regulations as well, so you would have access to both the webinar slides and the summary. And finally, a recording of the webinar will be available for you tomorrow for watching and sharing amongst your campus community. You will receive an email link with that, the recording tomorrow. Joining me today is my partner, Derek Teeter. Derek represents colleges and universities in complicated and prominent litigation cases involving federal and state regulatory statutes, governmental immunities, and constitutional rights cases, with a special emphasis on Title IX and the Clery Act. Very happy to have Derek joining us today. So with all of our information about the webinar out of the way, let's go ahead and get started. So I feel like channeling Carol Ann from Poltergeist and saying, they're here. We have received the final regulations. This is a culmination of the rulemaking process that began in November 2018 with an effective date of these final rules of August 14th, 2020. And remember, these final rules have the force and effect of federal law, federal regulation, and compliance is mandatory. So let's break down what these regulations actually do. They set the standard for administrative enforcement, and that's extremely important because that's different type of enforcement than the standard for lawsuits seeking money damages. These do not set the standard for litigation cases that you may have pending regarding Title IX violations. They will, though, necessitate institutional changes to your policies and practices. And Derek and I are going to talk today about some of those changes and really decision points that institutions have as you move forward towards compliance. They will not, though, alter institutional policies governing other forms of protected status harassment. So that's an important point as well. Now, the question everyone has asked, number one, when would they be released, which we now know the answer. On May 6th, they were finalized and issued, and then when do you need to comply? So as of right now, the compliance date, again, as I said earlier, is August 14th, 2020, and non-compliance can result in an administrative finding by the Office for Civil Rights. We anticipate that there's going to be and is in process litigation challenging these regulations. And what we think will happen is that they will attack the regulations on two main levels: procedural challenges, which is something that we see quite often in these types of lawsuits, and also that they are too broad. They go beyond the bounds of the law in terms of what the regulations require. So we will see possibly several cases in which injunctions will be sought. I think something that's important to really have in the back of your mind is that although we've seen nationwide injunctions before, they're now disfavored by many courts. So we may see these court cases go forward, and there may be injunctions issued to part or even just portions of the regulations, and they may only be applicable to certain clients, or even that there are certain parties to the lawsuit that are institutions, or even certain geographic areas. So that's important to remember when you think about compliance as well. So let's launch our first poll question. I think my institution will be in compliance by August 14th, may be in compliance by August 14th, or probably won't be in compliance, or will not be in compliance, won't be in compliance by the 14th. Let's see where you are right now, and we will show the results in just a second. Okay, so it looks like, at least right now, 61% say you will be in compliance by August 14th. So with that, let's talk about some of these compliance pieces, and I will turn it over to Derek to discuss really our first area of compliance, which is the scope.
Well, thanks, Haley. And there are a number of scope issues that are embedded in these final regulations. The first one, though, I think we need to talk about, and it's sort of the foundational scope question to all of this, is the idea of programmatic scope. So the regulation is quite clear that the Title IX obligations that are specified throughout the document apply to reports of sexual harassment, which is a defined term, that occur in the education program or activity of the institution that is receiving the federal funding. And sexual harassment captures not only quid pro quo and hostile environment harassment, but also the Clery crimes of sexual violence, domestic violence, dating violence, and stalking. There had been some criticism that the proposed regulation created the impression that Title IX obligations were limited to geographic areas where the institution had control, i.e. campus. But the final regulation makes clear that the programmatic scope includes campus, but also education programs or activities that move off of campus, that perhaps are hosted at a local park, or perhaps a student group is being chaperoned to some conference as part of the activities of a department. These Title IX obligations specified in the regulations flow with those programs or activities wherever they are, including off campus. And the regulation seeks to draw a specific bright line rule for houses owned or controlled by university-recognized student organizations that would primarily be fraternities and sororities. And it includes those houses within the definition of education program or activity. Now, it doesn't apply to off-campus private settings that are entirely unconnected to an education program or activity. So that's another bright line that the rule has drawn. For those instances that are outside education programs or activities in a private setting, then the guidance from these Title IX regulations doesn't apply. And in fact, the regulations say you should be resolving those, if at all, under some other policy, whether that's a student code of conduct or an employee handbook, but not the Title IX grievance procedure as the final regulation defines it. So there are numerous decision points that one could sort of unpack from this slide, but I think there are two that are sort of most prominent. One is, what relationship will your institution have with fraternities and sororities going forward? Because the programmatic scope is defined to include houses owned or controlled by university-recognized student organizations. So for those schools that have been debating whether to recognize or not recognize Greek organizations, this is a relevant consideration, because recognizing them then extends a school's Title IX obligation to their houses. The second decision point would be, will you, and if so, how, will you address non-programmatic sexual misconduct? That is to say, sexual harassment, sexual violence that happens off campus in those private settings unconnected to your programs. You have the ability to address that, but under these final regulations, not under the Title IX policy, something else. So if we're just to look at an example of how this distinction could play out, suppose that student A reports that student B sexually assaulted student A 3 weeks ago off campus in a private apartment complex in an adjacent town. And let's assume there are no university student organizations or employees who are involved, and there's no claim of any additional misconduct having happened thereafter, either on campus or in some other university operation. This would be an example of a report of sexual misconduct that under the programmatic guidance would fall outside the scope of the Title IX policy and would have to be addressed, if at all, under a separate policy specified by the institution. So another important scope question that is in these regulations, and one that could prove to be quite significant, I think, is the idea that the obligation to conduct a formal investigation is triggered only when the institution receives a formal complaint. And a formal complaint is something in writing that is signed or ascribed to by the alleged victim or the Title IX coordinator if he or she chooses to exercise that authority for the institution. So that's a limitation in scope in and of itself, this idea that you need this formal complaint from one of these two persons to trigger the formal investigation. But in the case of the complainant as alleged victim, the regulation specifies that that alleged victim can file a formal complaint only if they are participating in education programs and activities or they are attempting to participate at the time that the formal complaint is made. So for Me Too type cases, ones of historic import, where we may be receiving complaints today from persons who used to attend our institution but are no longer, those persons could not make a formal complaint under this grievance procedure, and it would be up to the Title IX coordinator, if there is to be a formal investigation, to initiate one. Another aspect of the temporal scope is that the regulation allows an institution, in other words, this is optional, to close a formal case if the respondent is permanently separated. That could be a respondent student or a respondent employee. So there's some decision points obviously packed into this. Will you address, and if so, under what other policy, complaints that are made outside this temporal scope? What if we get the complaint from the person who graduated 5 years ago that would be outside of our Title IX policy? Are we going to investigate that, and if so, under what policy? Another decision point, will you have the Title IX coordinator be the complainant if the alleged victim himself or herself is outside that temporal scope? And if so, what standards or factors are you going to utilize when the Title IX coordinator makes that decision? Because in the end, this is all sort of housed within an overall framework of, is the institution responding in a clearly unreasonable manner or isn't it? We can look at these nuances, but if we sort of are asking ourselves, is the department going to find us out of compliance or not in the end? That idea of being clearly unreasonable or not is sort of the subjective test that sits behind that. So let's look at another example of how this plays out. A Title IX coordinator receives a complaint from alumnus A who graduated in 2019. Alumnus A reports that student B, who is currently a junior, groped alumnus A's genitals without consent at a fraternity house recognized by the institution in 2018. So does this fall within that temporal scope? It doesn't for the alleged victim, because that alumnus is not currently a participant, nor is there any information to suggest that she is seeking to participate. So only the Title IX coordinator would have the authority to initiate a formal investigation under this provision of the final rule. Okay, another important scope question is the idea that these regulations apply with equal force in cases where the respondent is a student as well as in cases where the respondent is an employee, including administrators, staff, and faculty. So in essence, we don't get to have a special process, a special procedure for dealing with our sexual misconduct employee cases. And what's also quite interesting, and some of you have already sort of hit at this in your questions, the regulation isn't drawing distinction between cases involving at-will respondents and those who are under an employment contract. So for the non-lawyers on the call, a basic principle of the law in most states, if not all, is that an at-will employee can be fired at any time for any reason, as long as it's not a discriminatory reason that the law prohibits. In other words, you don't have to find that an at-will employee did something wrong to terminate them. But the regulation suggests that you can't discipline a respondent, including an employee, for sexual misconduct until you follow the precise investigation and grievance procedures that it specifies. So what does that mean for the case of an at-will employee? Can you still terminate them, or does it have to be for some justification other than the report of sexual misconduct itself? And we don't have clarity in the regulation, at least not to my eye, and I hope this is an area where the department will, through subsequent Dear Colleague letters or enforcement positions, make clear what the expectation is. The regulation also doesn't distinguish between classes of faculty, that is, adjuncts, tenure track, or tenured. So presumably those distinctions have to sort of disappear in terms of process. Now, the regulation also states that it does not supplant other institutional obligations under Title VII, which also has a prohibition on sex discrimination, or other employment laws that might exist. So there was this question of, will Title IX essentially subsume the field of an institution's federal civil rights obligations? And this final regulation is saying it doesn't. So in theory, a Human Resources Department might have some additional Title VII obligations, or at least a different analysis for purposes of Title VII compliance than would the school for purposes of Title IX. So a couple of decision points that are embedded in this scope issue. One, will you have that unitary Title IX grievance policy where you have one document and it governs all the different types of reports regardless of the respondent's status? And are you going to pull those discordant policies that currently sit maybe in an employee handbook, a faculty handbook? Are you going to eliminate all that and create one single unitary process and document? And if so, how long will it take you to navigate that process, including the faculty governance issues that may be embedded in that? And then another decision point would be, how are you going to coordinate your institutional compliance with Title VII and other civil rights laws, which oftentimes would be addressed through a Human Resources Department, and Title IX obligations, which are overseen under the Title IX rubric by the Title IX coordinator and under this very rigorous and sort of trial-like process that we now have. And neither of those is a particularly easy decision point to answer. So let's look at an example of just how this nuance could sort of come to pass. Say we have an at-will custodial worker who is accused of sexually harassing a female student in the hallway. Now, this worker has been on a performance improvement plan for a month because he was late to work, but he's complied with that. He's been doing what we ask, and but for the accusation of sexual harassment, the institution would have continued to employ him. But now he's been accused of this, and we're considering, do we terminate his employment? And the regulation isn't clear here whether we can terminate his employment because he's at will, or whether we have to go through that entire process, which would appear to create almost some contractual element to this employee's employment. We need that guidance, and I think the expectation or hope of most institutions is that they would still retain the ability to eliminate the employment of this worker because he or she is at will. And it could be that the rationale is irrespective of whether this conduct amounted to sexual harassment, it was unprofessional enough, or it's a separate reason that the custodial worker put themselves in the position to be accused in this way, and thus the institution is choosing to terminate that at-will employment. But we'll have to see what enforcement position the department takes. So with that, I'm going to hand it back to Haley for the next few slides, and then I will pick up in a moment.
Thanks, Derek. All right, so let's really talk about actual knowledge and what the final regs say about actual knowledge. The regs give us a definition of actual knowledge, that this is notice to an official with the authority to take action. And why actual knowledge is important is because that's what triggers the institutional obligations, the obligations in response when they have actual knowledge. And so you'll have to determine the official with the authority to take action as defined by the final regulation. Once actual knowledge is actually triggered, then the Title IX coordinator has to do a couple of things. And so let's talk through what the Title IX coordinator's responsibilities will be. First, they need to promptly reach out to the alleged victim and make sure that you're asking what the victim would like to do. Would they like to move forward under your process, providing information, and then also providing support services to that victim once you have actual knowledge. So it's important really that once that actual knowledge is triggered, the Title IX coordinator take that action. That must happen. However, it doesn't trigger the necessity to conduct a formal investigation or hearing process. Still, we have the ability, just like we've done before, of institutions to reach out to that victim, that complainant, and ask if they want to move forward or what they would like to do, and offer those supportive measures, as we're going to talk about in a little bit. So there's several decision points here for institutions that I think are very important. First, are you going to modify your mandatory reporting language and your policy? Most institutions right now require a large segment of their campus to be identified as mandatory reporters, that they must report if they are aware of sexual misconduct or sexual harassment, discrimination. They must report that to the Title IX coordinator. And so are you going to modify, as a decision point, that requirement? And I think that's something that you're really going to have to talk about and determine what the culture of your campus is, but that will be a decision point. And then you're going to have to take an inventory of the institutional officials who actually meet the definition of an official with the authority to take corrective action. So those individuals that will have actual knowledge once they become aware of complaints or issues that they can take corrective action on. So that's going to be important to really make sure that that is clear and identified by your institution. And we've, again, taken more of a blanket approach in the past, in which most employees of an institution are identified as someone who has to report within that policy, and they've been trained that they have to report. So if you're going to change that, how are you going to communicate that out to your campus community, which is another decision point that institutions will have to make. And then another kind of caveat or carve-out for actual knowledge that I just want you to be aware of is that there's a different rule for K-12 settings. And so actual knowledge at a K-12 setting is really imputed to any of the staff at that K-12 institution. So any staff member will have actual knowledge. So one of the questions that you need to ask, again, is do you have a lab school on campus? Does that lab school follow the policies of the institution and adopt the same Title IX policy? If it has its own separate policy, making sure that the actual knowledge definition aligns for K-12 institutions versus the definition of a higher education institution of an official with the authority to take corrective action. So those are things that you want to be considering as you're looking at changes to your policy. So let's give an example of this. So A clerk at a college's library overhears student A telling student B that she was raped in a dormitory last weekend. The clerk observes student A crying as she's telling student B that she hasn't been able to attend class and she's planning to file a Title IX complaint. So here, under the definition of the final regs, the clerk doesn't have actual knowledge to be impugned to the institution, to the college, because the clerk is not an official with the authority to take action. But when actual knowledge would occur is if you have a policy saying you clerk in the library are a mandatory reporter, you must tell the Title IX coordinator. Once the Title IX coordinator has actual knowledge, the obligations are triggered. So really understanding, that difference between actual knowledge is going to be important, and those key decision points that institutions are going to have to make as they move forward need to be considered. All right, let's talk about, again, once you have actual knowledge, one of the requirements of the Title IX coordinator is to provide supportive measures. And what does this mean? And this is what do supportive measures mean? Again, only after you have actual knowledge must you provide these. A couple of important things. Number one, they must be provided to the complainant or the victim in that particular case. And if you go through a formal process, it's very clear they must also be offered to the respondent once the formal process is initiated. There's a level of ambiguity in the final regs as to whether support services must be offered to a respondent before the formal complaint is filed. So if you have a situation in which a victim or complainant is meeting with the Title IX coordinator and they have determined they do not want to move forward, they only want supportive measures, support services that are offered, but they do not want to move forward, they don't want to do anything else, it's unclear right now whether or not, I think generally we wouldn't be reaching out to the respondent and offering supportive measures, but that ambiguity exists and we want you to be aware of it. Also, it's important to understand that the supportive measures that are offered must be non-disciplinary in nature, and that's very important, and that no disciplinary measures can be imposed until the investigation and grievance process has concluded. And so that's very, very important. So let me give you an example of what we're talking about there. So if an institution has a practice that once someone comes forward and makes a complaint, they issue a no-contact order for the respondent and the respondent only. That can be looked at as a disciplinary measure that you are putting in place as a supportive service. And so that would be a problem under the final regulations. But the question I'm sure I'm going to get from this, and we've already gotten from other clients, is what if you have a situation in which you always issue no contact orders for both parties once you receive that report? And that's an issue under the final regulations as well, because the regulations ask you to assess whether it's an unreasonable burden on the respondent. And so you have to have a factual assessment of each case, not just a practice of always issuing no contact orders to both parties. So make sure that that's clear as well. You could do that and determine based on the facts of the particular case that it is not an unreasonable burden for the respondent and that it is not then disciplinary in nature if it's a mutual no contact order. That decision could be made, but you can't just have a standard practice or policy that's every time you get one of these reports that's what's going to happen. Those no contact orders be issued. So remember that as well. And then the Title IX coordinator has the responsibility for offering and implementing any of those supportive measures that the parties would want to take advantage of. So let's talk a little bit about what the decision points are here. So number one, how will the Title IX coordinator oversee all of this? I think that's an important decision point. And do you want to deputize student support professionals to assist in working through some of these issues. That would be another decision point for the institution. The last decision point would be, remember you have obligations under Clery and the Violence Against Women Act to provide the rights and options document for those Clery crimes. So dating violence, domestic violence, stalking, and sexual assault, you must provide the rights and options document. So another decision point is, are you going to combine, at least for the VAWA crimes, your information, your support services with your rights and options, and provide one document, and who's going to do that? So those are all things that you want to think about in terms of supportive measures and your decision points. So let's talk next about interim removals and what that looks like under the new, under the final regulations. So it is permissible for students with an individualized assessment to have an interim removal, but you have to make sure that you are documenting the analysis of two very important points. Number one, an immediate threat, and number two, to the physical, and physical is important, health or safety of any student or other individual arising from the allegations of sexual harassment. So it's going to be very important that you have an individualized assessment, that you meet these criteria in determining whether an interim removal is appropriate under the particular circumstances. And if you do determine that an interim removal is appropriate, then that individual, the respondent, must be given the opportunity to immediately challenge that removal. And so some sort of process to immediately challenge the removal to say why that there is no immediate threat or to the physical health or safety of any student or individual. And one kind of, I guess, caveat for employees under interim removals is that employees still can be placed on administrative leave. So let's unpack this a little bit and talk about what are the decision points for interim removals. First, I think you need to consider whether or not you're going to utilize an existing threat assessment policy for interim removals, or if you're going to put separate language in your Title IX policy, and how you're going to make sure that the process has been identified and that there is, again, that opportunity to immediately challenge the removal. And then what does that process look like for the student who has been suspended or has an interim removal to challenge the decision? And how, who will be the decision makers of whether or not that challenge is, I guess, approved or makes a different decision than what the team assessment was of the interim removal. So I think a lot of institutions will be looking at how do they kind of pair up their existing threat assessment policies and even threat assessment teams to make these types of determinations. So let's walk through an example of this. A formal complaint is filed by student A, and student A is the former girlfriend of student B, and she is complaining because student B is trolling her on social media, trying to communicate with her after their breakup, and is texting and harassing her through all of these forms, and indicates that student B has caused her severe emotional distress as a result of these actions and wants this individual to be removed from campus. And so what do you need to do when you look at this type of example? And I think the question that, again, under the final regulations is, whether emotional distress can be part of this assessment of an immediate threat to the physical health or safety, whether emotional distress qualifies for that. What is the physical form? And I think this is something that, again, you're going to need a team assessment to determine whether or not that you can get to that level of establishing that there's a physical health or safety threat that would result in an interim removal. All right, so let's talk a little bit about the investigation process under the final regulations and what you need to be aware of as you look at your investigation process, some of the decision points as well. So the preliminary investigation requires the identity of the victim to be identified if it's not apparent from the report, so that the Title IX coordinator will have the obligation to, if they receive a report that says there was a sexual assault that happened in room 331 of Smith Hall on this night, but that anonymous report doesn't give you information as to the name of the alleged victim, that the Title IX coordinator will have to do a preliminary investigation to determine who the victim was and to perform that outreach to the victim as to what they want to do and provide those supportive measures. When a formal investigation process is triggered, so if the complainant decides they want to go through the formal process, then it's going to be important that you meet the requirements under the final regulations, which are similar to what we've been talking about over the last few years, which are a detailed written notice to the respondent and also that the complainant can see as well in terms of what is the complaint, that you have equal opportunity of both parties to present evidence and witnesses, including experts, that you have equal access to the evidence, and you have the opportunity to view the written report prior to the hearing. So some of the questions that we've gotten pretty consistently just in the last couple days about this, does the final regulations allow for the Title IX coordinator to serve as the investigator? Obviously, that question is important for smaller campuses, and the answer is there's no prohibition on allowing the Title IX coordinator to serve as the investigator in the investigation process, as long as you can show that there's no conflict of interest or bias on the part of the Title IX coordinator. And so if you can show that there is not if there's no conflict of interest, if there's no bias, I think that yes, the Title IX coordinator could serve as the investigator under the formal process. So that's one of the decision points I think you'll have to make. Who will actually the institution use to investigate, and what record-keeping system are you going to use to store and share the information, including access to evidence and opportunity to view the written report. That's going to be very important as well. And as Derek said, obviously, when he was talking about the Title IX coordinator, they can still serve as the complainant in cases upon which if the institution didn't investigate, it would be clearly unreasonable not to move forward. So let's give the example of the reluctant complainant, that in the preliminary investigation you've identified the reluctant complainant. This individual does not want to move forward, but now this is the third complaint that is very similar to the other two complaints against the same individual. And so now you've made a determination as an institution that it would be clearly unreasonable not to move forward as an institution. So you can still move forward. Now, obviously, if the Title IX coordinator is the complainant, the Title IX coordinator would not be the investigator in that particular scenario that we've outlined. So thinking through, again, those decision points as to who will investigate and how you're going to make sure that you're meeting all of these elements of the final regulation, and including providing access to the evidence and the opportunity to review the written report. Let's look at an example here. During the investigation, the respondent hires an expert who will opine that the complainant was not incapacitated at the time of the alleged sexual assault. The complainant doesn't have an expert and can't afford one. The investigator is dubious about the purported expert's credentials and reliability of his claimed methodology. What do you do in this situation? And under the final rules, I think the answer would be that the the respondent, would be able to include in the investigation process the expert testimony, the expert evidence that is provided, and then it would be up to the hearing panel to determine how much weight they want to give to that expert and how much they will rely on the expert during the hearing. And that's really going to be up to that hearing panel, but the investigation process would include it. Derek, I'm going to turn it over to you to talk a little bit more in detail about the hearing process.
Well, thanks, Haley. And this is obviously one of the most significant and potentially the most controversial aspect of the final rule. The idea that every case, if we're talking about a formal process, has to culminate in a hearing in front of a decision maker who is different than the investigator, effectively eliminating a single investigator or traditional civil rights model of case resolution. That simply isn't possible under this final rule. And the rule contemplates this hearing where, in essence, the body of evidence that has been developed in the investigation is then presented in the hearing context through testimony of the parties and witnesses that is subject to a contemporaneous cross-examination by the support person or advisor of the other party. That each party has their advisor who could be a lawyer, and that advisor is allowed to ask relevant questions of the witnesses and the parties in front of this decision maker. So this decision maker could be a single hearing officer. It could be a panel of persons like a jury. The regulation deliberately uses the individual or the plural, so I think we have flexibility there. But we're talking about a live hearing with contemporaneous participation by both parties and their advisors. And if one of them does not have an advisor, it is the obligation of the institution to provide an advisor to that person without charge so that that individual, that respondent, let's say, has someone who can conduct that relevant questioning or cross-examination on his or her behalf. So if this sounds a lot like a civil trial, it's because it does sound a lot like a civil trial. This is very much trending towards more of an adversarial court-like proceeding. It isn't all the way there, of course, but many of the attributes of that sort of live trial-like process are embedded in the department's expectations under the rule. Another piece of that is trial-like in nature is that it will be the obligation of the decision maker, or we might say the hearing officer or the hearing panel, to make contemporaneous rulings on relevancy, and if they're going to prohibit questions, to explain their rationale on the record. So if a party were to object that a particular cross-examination question was, for example, barred by the prohibition on invading sexual history, then the decision maker would have to rule on that objection and explain the rationale on the record, which is probably not something that an untrained layperson would be terribly comfortable doing. Now, the way that the department really is using to enforce this hearing process expectation is an interesting one. It simply says that if any person refuses to submit to that cross-examination, then the decision maker cannot consider that person's testimony or their statements in considering whether the standard of proof has been met. So that's a very important thing. In essence, if a person isn't willing to be subjected, then their testimony comes out of the equation and the case gets decided based on the other testimony of persons who are willing to be cross-examined, and whatever physical evidence or non-testimonial evidence like emails or text messages may be available. That hearing process culminates in a written decision from that hearing officer or panel that has findings of fact, that discusses the language of the policy, that includes a rationale for what the outcome is and why, and then is provided to the parties. So you can see, again, that's a very trial-like process. So the decision points that are embedded in this are myriad, but some obvious ones: who's going to be your decision maker or decision makers? Are you going to use a single decision maker model, or are you going to have a hearing panel? Who's going to train these persons, and what sort of training are you going to expect of them? Who are you going to use as support persons for those parties who are unable to secure a support person for themselves? Will you have volunteers? Will you hire someone to do that from outside? What technology will you use to effectuate the hearing? So the rule does say that contemporaneous participation can be satisfied by having the parties in separate rooms, as long as the technology is adequate to allow them to participate at the same time. You don't have to put everyone in the same room to achieve this. By the same token, you can't record somebody's testimony and then let the respondent hear it after the fact, an hour after it's been given. That wouldn't work. But these technology questions are then embedded here, much like what we've had to do as we navigate COVID. Are you going to use a Zoom platform, a GoToMeeting platform, direct closed-circuit television, what have you? These are all things that have to be thought through and worked out. So here's our next poll question. Given how onerous, I suppose, the obligations of a hearing officer could be, my institution will probably have to hire someone to be a hearing officer. If you think that's true, click true. And if false, click false. Give you just a moment to respond. And so it looks like about a third of you are saying now you would have to hire someone, and 2/3 are not. And I suppose this is something that could depend on the complexity of the particular case as well. If you had a case where each party was represented by a lawyer, you might decide that you need to outsource that in a way that you wouldn't if a case didn't involve attorneys and maybe didn't have quite so serious a form of sexual harassment. So the next slide, which relates to the hearing and also the investigation, and is obviously a controversial point. What standard of evidence can an institution use in assessing whether or not there's a violation? Well, you can use preponderance or clear and convincing. The regulation gives you the option to choose either of those two different standards. But whichever one you choose, you must apply it uniformly for all cases regardless of the classification the respondent has. So to be concrete, you can't use preponderance for students, but use clear and convincing for faculty, or vice versa. It has to be unified. There is a presumption from the time the investigation starts until the time a decision is made finally, that the respondent did not violate the policy. So this presumption of innocence, if you will, is adopted by the regulation and guides the work. And that actually has to be articulated early on in the written notice that goes to the parties. Now, the institution bears the burden of proof and of collecting the relevant information, which I think is sort of interesting, that the regulation is creating this adversarial relationship where the parties are cross-examining each other, and the institution is supposed to be objective, but at the same time, the regulation says the institution is the one bearing the burden of proof. I'm not sure exactly what to make of that, except it's clear that the institution has the burden to collect evidence from which that decision can be made, and it can't simply put that burden upon the parties to the case. So what decision points come out of this standard of evidence discussion? Well, which standard are you going to choose is the obvious one. But then more complicated, how will you bring alignment between what you choose for your Title IX policy and maybe a different standard that is in the faculty handbook? And what faculty governance processes need to be made there? And also, how will you communicate to your community about which substantive standard you end up selecting? Because some segment of that community may disagree with the qualitative choice you've made, whichever one it is. So the regulation also addresses the subject of appeals, and whereas the proposed regulation from 2018 said that an appeal was optional, although it had to be equitable, the final rule says you must provide an appeal. It has to be available to either party. and it specifies 3 grounds upon which that appeal has to be available. Procedural irregularity that affected the outcome, new evidence not reasonably available that could have affected the outcome, or a conflict of interest by the institutional participants that affected the outcome. The regulation doesn't say these are the only grounds for appeal, but it says that these are grounds for appeal that you must have. So presumably you could include additional grounds if you wanted to, as long as they were grounds that would be fairly available to both parties. You couldn't, for example, allow one party to appeal that the punishment was too strict and not allow the other party to appeal, arguing it was too lenient. So an important piece that's embedded in all of these, that idea of affecting the outcome, we lawyers would call that prejudicial error. In other words, whatever you did wrong under the regulation has to be significant enough that it actually affected the outcome, or in the case of new evidence, could have affected the outcome, because by definition, it wasn't available and we don't know what effect it would have had on the outcome. But harmless errors, things that don't matter, wouldn't be a basis for a successful appeal. The non-appealing party has to be given a chance to respond to the appeal in writing under this proposed rule. So, decision points here. Are you going to offer any additional grounds for appeal, or will you limit yourself to the 3 grounds specified in the regulation? And then who will be your appeal officer? Because the regulation says it can't be the investigator who worked on the case, and it can't be the decision maker or one of the decision makers who issued the initial decision. And it can't be someone who has a bias or a conflict of interest at issue. So we sort of are carving out more classes of persons who it can't be, which narrows the universe of who it can be. So with that, I'm going to bump it back to Haley for a couple more slides, and I'll close this out after she's done. So Haley, informal resolution.
All right, so informal resolution under the final reg says it's only permissible after a formal complaint is filed, and that is an important distinction. Only after the formal complaint is required. So you cannot compel your students to agree to informal resolution as a condition of enrollment at your institution. It's only after a formal complaint is filed, and then both parties must provide voluntary written consent after receiving the detailed notice that we talked about before of the allegations and an explanation of your informal resolution process. So those are the factors that must be met in order to proceed with this informal resolution. Informal resolution is not permitted where the accused is an employee that's accused of sexually harassing a student. So let's talk about the decision points here. So the first, will you create an informal or optional investigation and adjudication process? And what does that look like? Again, only after the formal complaint is filed. And then the second decision point, are you going to train your staff to serve in this process? Will they be a quote-unquote mediator, and what does that process look like? I know we've talked about in previous Title IX trainings that mediation is not appropriate in certain circumstances. Only now, under the final rules, you can do mediation as long as it's after the formal complaint has been filed, and again, not permitted when an employee has been accused of sexually harassing a student. So, is mediation one of those pieces of your informal resolution policy that you're going to allow for? And finally, then, just considering some institutions have used processes like restorative justice, and how does that system then fold into an informal resolution process after the formal complaint has been filed? So let's look at an example here. So student A makes a verbal report to the Title IX coordinator that student B is sexually harassing student A by repeatedly and persistently pursuing a romantic relationship with A, despite the fact that they've been told no multiple times. The Title IX coordinator contacts student B and suggests that this could be informally resolved by student B simply apologizing to student A, leaving her alone, and participating in professional coaching. it appears under the final regulations that this would violate the regulations because there's only been a verbal report and there hasn't been a formal complaint in which the parties have had voluntary written consent, have signed voluntary written consent to participate in an informal resolution process. All right, so let's talk briefly because we're running out of time. There's a lot to cover here in the many pages of the final regs and guidance. So let's talk about training. Training requires all institutional participants in the process. You must provide training that is for all of these participants in the actual process that is non-biased and does not rely on stereotypes. And those participants in the institutional training you must retain the training materials and those that have participated for 7 years after the training and have that posted on the institution's website. So very clear decision points here. What training are you going to use? How are you going to retain the records, not only of the actual training, but those who participated in the training, and how will that be published on your website? Where are you going to publish that, and what makes sense in how you can make it clear what training that all of your participants have been properly trained. The last one I'm going to cover before turning it back over to Derek is records preservation. And the final regulations say that you must keep these records, and we're going to go through the categories, but for 7 years. So that does align with Clery in terms of making sure that you're keeping your records for 7 years with the Clery Act as well. That includes formal cases, informal resolutions, and cases where only supportive measures were provided. And you must include the rationale for not proceeding formally with that documentation. It's also important to understand that parties have the right to access these records, and that the decision points that you're going to have in terms of record retention and preservation are going to be, what system are you going to use to preserve those records? How will you manage the right of access to those records, whether it be in person or electronic access? And who will store the records? Whose responsibility is this going to be? Is this potentially going to be another responsibility of your Title IX coordinator, or is your general counsel's office going to store the records? Or in some cases, we've seen that the police departments or campus safety are storing records. So those are all going to be decision points regarding record preservation as well. Derek, I'll turn it back over to you to talk about the religious exemptions.
So there are a number of private religious institutions on the webinar, and a significant change the regulation makes is that Title IX's religious exemption is now what we would say self-executing. So the Title IX statute says that the law doesn't apply to the extent that it conflicts with the religious tenets of a religiously controlled institution. Previously, the department's regulations suggested you had to apply for and obtain that approval from the department before you could rely on the exemption. Now the regulation says you don't have to pre-seek that approval from the department. That is an exemption that you could raise during the pendency of a Title IX complaint made against you, either at the department level or maybe in litigation. But that pre-approval is still available as an option for schools who would want the assurance that the department agrees with their position that they are eligible to claim the exemption. Now, the exemption is available to an institution that is, quote, controlled by, close quote, a religious organization, and where some aspect of Title IX conflicts with a religious tenet of the organization. So not every private school is going to qualify as being controlled by a religious organization. But for those that do, the exemption is then available if you can articulate that conflict between the regulation and a bona fide tenet of the religion. So some decision points here: do we qualify as an institution controlled by a religious organization? And there's all sorts of case law that talks about exactly what you would have to show. Do any of the current elements of the regulation conflict with our religious tenets? And if so, are we going to prospectively seek to have the department agree with us, or are we going to sit on that right in the event that we have to articulate it? So here's an example. Say we have a college controlled by a church denomination that believes sexual harassment is a grave sin and that utmost sensitivity and grace should be shown to alleged victims. And the church denomination has developed its own protocols for investigating reports that do not permit cross-examination. The church believes that cross-examination is inconsistent with its biblical obligations in responding to reports of abuse. So could that college controlled by the church denomination claim it is exempt from the provision of Title IX requiring there be live cross-examination at a hearing? There's nothing in the regulation that says you couldn't do that. If you have that conflict between a religious tenet and that directive, then you fit within that exemption. It is not limited to gender stereotype, single-sex restrooms, and these sorts of things, which historically the exemption had been more broadly utilized for. Okay, last few points. The regulation explicitly says that if there's a conflict between Title IX and FERPA, you follow Title IX. This eliminates the need to seek FERPA waivers in Title IX cases, which some of you were doing in an abundance of caution. That's not strictly necessary anymore. And so I think that's a decision point whether you stop using FERPA waivers or not. The regulation also contains an explicit preemption provision that essentially says, look, as it pertains to how the Department of Education has defined sexual harassment and the various elements of the investigation and grievance process, you've got to comply with this federal regulation, even if state and local laws are to the contrary. So decision points for you, figure out if you're in a jurisdiction where there's a conflict between state, local law, and the federal law, and if so, try to figure out whether you can get clarity either through an attorney general opinion or otherwise as to what you're supposed to do. And you could see how this could play out. A college is located in a state that's passed a law defining sexual harassment for purposes of Title IX policy as any unwelcome conduct of a sexual nature. That's not consistent with the new definition in the Title IX regulation, which says it has to rise to the level of being severe, persistent, and pervasive, creating a hostile environment. So you could also have a state law that precludes any direct cross-examination, which we know is inconsistent with the Title IX regulation. We'd like to try to resolve that, if we could, through some opinions before we have to assert that defense in a lawsuit. So lots of questions, and we appreciate you letting us cover as much as we can, but we're out of time, so I'm going to turn it back to Haley just to offer a few closing procedural remarks, and look forward then to interacting with you offline through email or phone. Haley?
Thanks, Derek, and thank you all for joining us for our program today. We hope the information we provided was helpful to you and your organization. If you have not done so already, please click on the survey icon at the bottom of your screen to complete a very short survey. This feedback assists us in providing future quality programming. As a reminder, a recording of the webinar will be available tomorrow for viewing and for sharing. The link will be emailed directly to you, and if you go into the resource icon folder, you will get a copy of the slides from today, and you will also get a copy of the summary that Husch Blackwell created as well. This concludes our webinar. Thank you very much.